Hello and welcome to another episode of Vienna Arbitration Talks. Today I'm very happy to host here with us Annet van Hooft from Paris. Hi Annet, welcome to Vienna.
Thank you Peter.
Annet is in town for the Vienna Arbitration Days, which is one of the leading conferences in Central Europe, where she was speaking yesterday. Annet, unfortunately I had to miss the Vienna Arbitration Days this year. I wanted to ask you, how was the conference?
It was excellent. It was really very good. So for all of you who have never been, next year you should be there. Promise.
Thank you. Let me introduce Annet shortly. Annet established her own practice about 2 years ago, where she acts as counsel and arbitrator. She has worked for a number of big law firms. She was partner and co-head of the International Dispute Resolution at Bird & Bird. And before that, she had also worked for Jones Day and Cleary Gottlieb. Annet was a counsel at the ICC court, and she was also the vice chair of the ICC Commission on Arbitration and ADR. So, Annet, our topic for today is document production in arbitration. We hear a lot of criticism of document production, and I wanted to ask you, do we need document production at all?
Frankly, yes, I think we do need document production. Let me take a step back. Yes, there's a ton of criticism, a ton. It's costly, it's time consuming, the process in itself is abusive, it's often abused. So yes, there's a ton of criticism. And I think you could even say that the Prague rules in a way are a form of criticism, because as you know, the Prague rules, they don't want e-discovery. They say that in general, arbitral tribunals should discourage discovery or document production. So you could see that as a form of criticism. But I personally genuinely believe that there is room for document production, that it's an important mechanism, not necessarily for all cases, but I think we should be careful that because we have criticism, it doesn't mean we need to abandon document production altogether. It would be throwing away the baby with the bathwater. So no.
One of the ways to manage document production is by using the IBA rules on taking of evidence. What do you think about the IBA rules?
I think the IBA rules are really a success story. As you know, they were last revised in 1999.
Which is, I want to ask you, do you think there is a need to revise them? I mean, 11 years is quite long in international arbitration.
Yes. How can I say? 11 years in arbitration used to be not very long. I mean, in the past, the ICC rules were revised every 10 years, but we have all seen that things are accelerating. Is there a need to revise them? Let me first answer the question of whether they're useful. I think the IBA rules are an excellent tool to manage the document production process, both for parties and for arbitral tribunals. I see them used a lot, I would almost say all the time, not very often as rules, like very few arbitral tribunals will say, and it will be fully, and I will fully apply this, they will not be copied wholesale into a procedural order, but they're often referred to as guidance. Do they need to be amended? I find that a bit strong. Do they need to be amended? Probably it's a good moment to see whether certain articles can be further improved. And I understand that a subcommission of the IBA Arbitration Commission is actually doing exactly that work, looking at whether any amendments will be necessary, and I think they will report on that in the fall at the IBA conference.
Oh, I see. Let's see what they find out. Right now, let's talk a little bit about the timing of document production exercises. What do you think is the best stage of the arbitral proceedings to do document production?
Well, how can I say? There's obviously always difficult to give hard and fast rule, because arbitration is how can I say, is tailor-made justice. What you see generally is that you do document production after the first round of submissions, after the parties have exchanged the first round of submissions, which has as an advantage that document production comes early enough that the parties can actually use it in the next round of submissions, but not so early that as a tribunal you have like totally no idea why a document might be relevant at all. So that is what you generally see, and generally that is the appropriate stage. Doesn't always mean that it's easy for a tribunal to actually assess the relevance already, but still, you do have key indicators.
So once we are at this stage of formulating requests, I can imagine things can go wrong. So what can go wrong when you are formulating requests?
Well, Peter, I'm afraid to say lots of things can go wrong. They really can. I think one common problem with the formulation of the request is that we still very often see that they're formulated in a very wide manner. And I call this the request for any and all, everything.
Everything.
Any and all, everything, you name it. From the opposing party and its group companies. And you really, even though quite a lot has been written about it, you really still see those kind of requests. What you also will see a lot is requests that do not use the word all, so they prevent that, but they don't contain any other limitation. So there is no limitation in terms of subject matter. There's no limitation in terms of time period. There's no limitation in the indication of the author or authors of the documents that they're looking for. So that still leaves you with a very broad category, and it also becomes very difficult to explain to a tribunal why all of that would be relevant and material to the outcome of the case. Another thing you will see is parties do try to limit, and so they will ask for all documents leading up to the period of 15 March 2016, request number one. Well, it's still broad, but at least there's a time limitation.
Exactly.
Next request, all documents from 15 March 2016. And so,
which is also limited in time.
Which is also limited, except that when you look at them together, there's not much limitation left. So that is really one of the issues. I think another problem is that for some parties, maybe they get so excited about it, they will make an enormous number of requests. And I think you should also think about the perspective that gives to the tribunal. I mean, you have done, or parties have made their first round of submissions. Evidence is already on the record. Do you really need such a huge number of requests with such a wide group of documents? I really question it sometimes. It may, under circumstances, it may be more effective to focus on the documents that you really need and that are really relevant and material for the case. And that brings me immediately to the next issue. So you have the requirement that they're relevant to the case and material to its outcome. Often, at least in the reference schedule that I ask the parties to use, parties will have to indicate a reference to the parties' submissions. They're very often, these references are wrong, so I would really suggest you check them before you submit it. And relevance and materiality is not always explained very well. Now, materiality may be difficult to explain, but relevance you should be able to explain fairly well. There's another thing that I've noticed is that more and more parties will make a kind of general submission. So yes, on the one hand there is the reference schedule.
An introduction, you mean?
Exactly, they will make an introduction, and sometimes the introduction really is that. It's 6-7 pages of introduction, of things that come back many times, arguments that they explain in a little bit more detail to avoid repeating them 20 times over in the reference. But sometimes they become standalone submissions on their own, and you can then wonder if they don't defeat the efficiency of the reference schedule.
When you receive all this from the opposing side, then I guess you have to formulate objections. So what can go wrong in formulating objections to these requests?
Again, there's huge potential. There's a lot of potential for things that can go wrong. What are the kind of objections that you see? On the one hand, you see the objections that are more based on Article 3 of the IBA rules, so lack of relevance, lack of materiality, overly broad. Some parties have as a tendency that if they have found one argument, they will only put that one in, one objection, and that's it. In certain cases, there may be several objections, in which case it may be advisable to put more than just one objection in, because what for example, if the tribunal disagrees with the specific objection that you have raised, but would have agreed with another one that you didn't mention. So that is one of the things you need to think about. Another thing is, we will often see that parties invoke confidentiality, and you can have several confidentiality. How can I say? Confidentiality can, on the one hand, relate to, for example, confidential license agreement. On the other hand, you have the commercial and technical confidentiality. Now, with both kinds of confidentiality, I think it's very important that you explain why it's confidential. Just not say it's a license agreement and so it's confidential, or it's a document that is interesting for a competitor, so must be confidential. I mean, say a bit more about it. Make the effort to explain well to the tribunal why it's confidential and why that matters to you. I think those are very important things to keep in mind when you formulate your objections. Definitely.
Now we are at the next stage, so the tribunal is deciding about these requests. How do you deal with such requests when you act as arbitrator?
Well, how can I say? I have noticed that document production request can be a lot of work. And one of the first debates that you may have among arbitrators is whether actually you should fully motivate your decision on the request, or whether you should just limit yourself to grant it or deny it. And there are different arbitrators who have different views on this issue. But that is one of the things that often comes up. I generally, not always, but I generally think that it's good to explain how you reach your decision, or at least give some reasoning.
So what would be the extent of this explanation of the reasoning? Is it enough to say too broad, or would you say too broad because this?
I would be inclined, but once again, it depends on the case. It depends on many factors. But I would say that generally you will be able to say the request is overly broad, or the request is not sufficiently narrow and specific, because there is no time period, there is no subject matter, there are no authors. So you could be a little bit more specific in that. And as I said, I believe it's important because it does more justice often to the work that parties put in. On the other hand, sometimes the requests are so voluminous that it can be justified that as a tribunal you only work with granted or denied. Of course, in how can I say, in the ideal situation, you will have been aware as a tribunal that very substantive requests for document production would be forthcoming, and you have discussed this with the parties at some stage, that the most appropriate way to deal with this is to not motivate in any way your decisions.
Let's deal with some of the problems of these requests. So what do you do when the request is too broad, for example? What can you do as an arbitrator?
Well, yeah, you have several options. I mean, there's a simple option. You basically say, too broad, denied. What you see in practice, however, is that with certain requests, and maybe it's not always for the right reason, but with certain requests, an arbitral tribunal will understand what document the party is looking for, or which category of document the party is looking for, and they will grant it subject to conditions. And the conditions generally mean that the arbitral tribunal has narrowed the request. You need to be a little bit careful with that, because as a tribunal you don't want to end up, how can I say, saving a party from itself or doing the work of a party. However, as I already alluded to, sometimes you're concerned because either you think the document would be really relevant and you would like to see it yourself, or you believe it would be incredibly relevant for an expert and that it wouldn't make any sense for that expert not to have that document. So those are concerns that do play a role. And in this regard, what I should maybe mention, it was in fact a suggestion of Philippe Pensol. We had an event with the Paris Bar earlier this week, and he said that in that regard, what may be a better approach is that you reject it because it is not narrow. But then, as an arbitral tribunal, you generally have the power to order document production yourself, documents that you believe are relevant, and that you order those relevant documents using own power. And once again, I think in an ideal world, you would make sure that you mention this possibility timely to the parties.
To say that you will maybe take use of their power.
Exactly, that you will maybe at the stage of document production, you will well, how can I say, and as you are assessing what evidence may be relevant going forward, that may for you be a good moment to use your power to order the production of further documents. Yes.
How about the burden of proof? Is it relevant who has the burden of proof when you're deciding on the request?
Well, that's another of the great debates. I would almost say there are two schools on that as well. There's a school who says you can only order the production of a document when that party has the burden of proof, and the reasoning then broadly goes like, if you don't have the burden of proof, it's not your problem if you don't have the document. And there's obviously there's another school who says no, that's wrong. Burden of proof is really a procedural mechanism that where at the end of the proceeding, if something is unclear, undecided, that you decide to whose detriment that is. So it's a different thing. So there are really different thoughts on that. And now obviously even if you go with the school that says it's not strictly only the burden of proof, then you still will need to draw a line. And so then the questions will arise, what do you do with requests that solely serve to prevent a party from submitting any further evidence on a certain point at a later stage? Is that relevant? So it's not always easy to decide on those things. And I've also seen instances where if the tribunal puts too much of an emphasis on the fact that the burden of proof may or may not play a role, because this is also something you can discuss with the parties at the outset, that you then get entire theoretical treatises on how the burden of proof according to a certain law is. And it may be very difficult to already fully decide on that, and especially in the abstract at the document production stage. So not easy.
So after you have read the request, then you obviously then read the objections. How do you deal with objections, for example, that the documents have been lost?
Yeah, I find those difficult in the sense that sometimes you can't do much other than assume at face value that these assertions are true. In other instances, how can I? Well, generally it's helpful if parties at least explain why they're lost. I mean, lost. Left them in a bag in the metro. The whole IT system has been destroyed. The building caught fire. The company was sold. I mean, why did you lose documents, or why do you no longer have custody or control over them? I think, yeah, that is important to look at that. But those are definitely not easy questions. Certainly not.
What about objections of confidentiality? Are these objections effective?
I see in practice that they don't work very often. Tribunals will be inclined to allow production subject obviously to appropriate measures, and those appropriate measures are often redaction of documents and or confidentiality undertakings from the parties receiving them. It's a little bit different when you talk about privilege. Privilege, most tribunals find it much harder to deal with, because with privilege, especially in international arbitration, you often have the situation that one party's in-house counsel's communications are protected, the other in-house counsel's parties' in-house counsel's communications are not, and then how can I say there can be a very big disbalance between the two parties. On the other hand, parties may have known from the beginning. I mean, the US counsel was counting on the confidentiality, the Italian counsel never was. So how do you take into account that disparity? And I think what you see very often is that the tribunals will apply the most protective rule, and so they will rule that everything is protected as if we were all US in-house counsel. But there's also quite a lot of debate about this because certain persons say, well, look, if you look at the expectations of the parties, which is also a criterion in the IBA rules, they knew all along. So why, in the interest of fairness, which is a fairly general interest, why treat this the way you treat this? Yeah, not easy.
Now, a question that I've always wanted to ask someone.
I'm getting scared. I'm getting
It's
worried.
not that bad. Yeah. It's not that bad. So, when a party does not produce the document that as ordered by the tribunal could often say it would draw adverse inferences in this case. So, what are adverse inferences, and what does this actually mean?
Well, one of the problems with adverse inferences is that parties will often say, and they haven't produced, and now we want an adverse inference. Mm-hmm. But if you don't actually tell the tribunal what you think it should be, mm-hmm. you're not helping them, you're not making their life easier, because, I mean, there are often a lot of things you can assume on the basis of the fact that a document has not been produced. So I think it already helps if you specify what it is. How can I say, we know at least that in Paris, we know from a case from the Court of Appeals that arbitral tribunals are allowed to draw adverse inferences. That doesn't render their award challengeable. Mm-hmm. But from the same case, we can actually see that the tribunal was incredibly careful. So there was evidence on the record, and the adverse inferences, how can I say, evidence on the record, sorry, I should be clear, that went in a certain direction. And I would say that the adverse inferences were really only used to, how can I say, as a second line of argument or to top it off. Mm-hmm. But I've rarely seen a tribunal go straight in and put in a blank adverse inference, also without any input from the party, what that should have been. Yeah.
So now my final question for today, and this is the most difficult one. How can we do document production better?
Well, how can we do it better? I think we can all do better. First of all, one of the things we could do, either at the case management conference or maybe at a later stage, just before we go into document production, is that the parties and the tribunal discuss with each other their expectations and understandings. I think that would prevent a lot of things. Are the parties expecting a motivated answer from the tribunal, or would they be happy to only have granted or denied? Burden of proof, relevant, yes or no. On certain things, the tribunal could already give guidance, and also the tribunal could use this as an opportunity to imprint once more on the parties that, you know, if the IBA rules say relevant and material, it means something. If they say a limited category of documents, it means that there's some limitation. So I believe that having more conversations about that with those who are concerned by it in a given proceeding,
before,
exactly before, not after, because after it's a bit late and you may have unpleasant surprises, in fact for the parties, but also for tribunals. Yeah.
Thank you so much, dear Annet. Hope we meet again very soon, I guess at the latest at the Paris Arbitration Week, but thanks for today.
Thank you, Peter, for having me, and thank you very much for the tulips. That's incredibly attentive.
We got them brought in directly from the Netherlands, just for you.
I thought so.
Dear viewers, thank you for watching us today. Don't miss our next episode, but until then, best wishes and greetings from Vienna. Thank you. Thanks, Annet.